Hello, friends and insiders. This is Government Unfiltered. I'm Dan Williams. In my first episode since the Mueller report, I'm going to be helping to explain the Emoluments Clause. Recently, President Trump attended the G7 summit and suggested that next year the meeting could be held at one of his properties in Florida. This sparked a number of reports in the media saying that a meeting at his property could violate the Emoluments Clause of the Constitution. Then on Friday, September 13th, the Second Circuit made a decision on a case brought forward by the Citizens for Responsibility and Ethics in Washington, saying that they are able to proceed with a case against President Trump where they allege the Trump International Hotel's lease with the General Services Administration violates the Domestic Emoluments Clause, and that payments for services made to the Trump International Hotel by agents of foreign governments violate the Foreign Emoluments Clause. All of this news got me to wondering, what exactly is the Emoluments Clause? And if President Trump follows through with his suggestion to hold the G7 summit on his property next year, could this be a potential violation of the Constitution? Well, thanks to a recent report titled The Emoluments Clauses of the U.S. Constitution, a report prepared by the Congressional Research Service and posted on August 23, 2019, it helps to provide background on these emoluments clauses and additional court cases that are in various stages of litigation against the president. What is the Emoluments Clause? That's the topic of this episode. The Emoluments Clauses of the U.S. Constitution. Recent litigation involving President Trump has raised a number of legal issues concerning formerly obscure constitutional provisions that prohibit the acceptance or receipt of emoluments in certain circumstances. This episode provides an overview of these constitutional provisions, highlighting several unsettled legal areas concerning their meaning and scope, and reviewing the status of ongoing litigation against President Trump based on alleged violations of the Emoluments Clauses. The Constitutional Provisions. The Constitution mentions emoluments in 3 provisions, each sometimes referred to as the Emoluments Clause. The first is Article 1, Section 9, Clause 8, the Foreign Emoluments Clause. It says, "No person holding any office of profit or trust under the United States shall, without the consent of Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state." The second is in Article 2, Section 1, Clause 7, the Domestic Emoluments Clause, aka the Presidential Emoluments Clause. It says, "The President shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them." The third is from Article 2, Section 6, Clause 2, the Ineligibility Clause. It says, "No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office." Purposes of the Emoluments Clauses. Each of the Emoluments Clauses has a distinct but related purpose. The purpose of the Foreign Emoluments Clause is to prevent corruption and limit foreign influence on federal officers. The clause grew out of the framers' experience with the European custom of gift-giving to foreign diplomats, which the Articles of Confederation prohibited. Following that precedent, the Foreign Emoluments Clause prohibits federal officers from accepting foreign emoluments without congressional consent. The purpose of the Domestic Emoluments Clause is to preserve the President's independence. Under the clause, Congress may neither increase nor decrease the President's compensation during his term, preventing the legislature from using its control over the President's salary to exert influence over him. To further preserve presidential independence, the clause prohibits a sitting president from receiving emoluments from federal or state governments, except for his fixed salary. The purpose of the Ineligibility Clause is to preserve the separation of powers and prevent executive influence on the legislature, and vice versa. To that end, the clause prohibits federal officers from simultaneously serving as members of Congress. Moreover, a member of Congress may not hold an office if it was established during his tenure or if the emoluments of that office were increased during his tenure. Officers subject to the Emoluments Clauses. In terms of the persons to whom they apply, the scope of the Domestic Emoluments Clause and the Ineligibility Clause is clear from the text of the Constitution. The Domestic Emoluments Clause applies to the President, and the Ineligibility Clause applies to members of Congress. The scope of the Foreign Emoluments Clause is less clear. By its terms, the clause applies to any person holding an office of profit or trust under the United States. The prevailing view of the clause is that this language reaches only federal and not state officeholders. According to the Department of Justice's Office of Legal Counsel, OLC, which has developed a body of opinions on the Foreign Emoluments Clause, offices of profit include those that receive a salary, while offices of trust are those that require discretion, experience, and skill. There is a disagreement, however, over whether elected federal officers, such as the President, are subject to the Foreign Emoluments Clause. Some legal scholars have argued that, as a matter of original public meaning, the Foreign Emoluments Clause reaches only appointed officers and not elected officials. While there is some historical evidence in support of this view, other evidence may point in the opposite direction. Moreover, the OLC has generally presumed that the Foreign Emoluments Clause applies to the President, and a recent district court opinion came to the same conclusion. The meaning of the term emolument. Black's Law Dictionary defines an emolument as an advantage, profit, or gain received as a result of one's employment or one's holding of office. There is significant debate as to precisely what constitutes an emolument within the meaning of the Foreign and Domestic Emoluments Clauses, particularly as to whether it includes private arm's-length market transactions. The only two courts to decide this issue adopted a broad definition of emolument as reaching any benefit, gain, or advantage, including profits from private market transactions not arising from an office or employ. Standing to enforce an alleged violation of the Emoluments Clauses. Whether the Emoluments Clauses may be enforced through civil litigation is an open question. The doctrine of standing presents a significant limitation on the ability of public officials or private parties to seek judicial enforcement of the Emoluments Clauses. Standing is a threshold constitutional and prudential issue that concerns whether the person bringing suit has a legal right to a judicial ruling on the issues he has raised. Standing is grounded in Article 3 of the U.S. Constitution, which limits the exercise of federal judicial power to cases and controversies. To establish the standing requirements of Article 3, a plaintiff must identify a personal injury, referred to as an injury in fact, that is actual or imminent, concrete, and particularized. The injury must additionally be fairly traceable to allegedly unlawful conduct of the defendant and likely to be redressed by the requested relief. Beyond these constitutional standing requirements, courts have at times recognized a set of prudential principles that are relevant to the standing inquiry. Because such limits are not constitutionally mandated, Congress may modify them if it does so expressly. In general, prudential principles require that 1. A plaintiff assert her own legal rights and interests, as opposed to those of a third party. 2. The plaintiff's complaint fall within the zone of interests covered by the legal provision at issue. And 3. The plaintiff may not assert what amounts to a generalized grievance that is more appropriately addressed by the representative branches of government. Different plaintiffs in ongoing Emoluments Clause cases have relied on various theories to support standing, with mixed results. Private parties, including business competitors and government ethics watchdog groups, have asserted injuries in the form of increased competition in their industries and diversion of resources to combat the alleged constitutional violations. States have alleged injury to proprietary interests connected to ownership of competing businesses and harm to their quasi-sovereign interests in the federal system, among other things. Some members of Congress have relied on the alleged deprivation of their opportunity to vote on the acceptance of emoluments under the Foreign Emoluments Clause. Significant litigation involving the Emoluments Clauses. Until recently, there had been no substantial litigation concerning the Emoluments Clauses. However, since 2016, a number of private parties, state attorneys general, and members of Congress have filed lawsuits against President Trump alleging that his retention of certain businesses and financial interests during his presidency and his failure to seek congressional approval of interests relating to foreign governments violate the Foreign and Domestic Emoluments Clauses. 3 major federal lawsuits concerning the Emoluments Clauses have been filed. In Citizens for Responsibility and Ethics in Washington versus Trump, a nonprofit government ethics watchdog, along with various organizations and individuals associated with the food services or hospitality industries in New York and Washington, D.C., alleges violations of the domestic and foreign emoluments clauses through President Trump's receipt of payments from the federal government and various foreign government officials at different Trump Organization properties. For example, plaintiffs allege that the Trump International Hotel's continuing lease with the General Services Administration violates the Domestic Emoluments Clause, and that payments made for services made to the Trump International Hotel by agents of foreign governments violate the Foreign Emoluments Clause. President Trump moved to dismiss the suit, asserting that the plaintiffs lack standing and that the term emoluments does not extend to arm's-length commercial transactions. The district court dismissed the case for lack of standing on December 21, 2017. The plaintiff's appeal on the standing issues had been pending before the circuit court, but on September 13, 2019, the Second Circuit Court vacated the decision by the district court, and that decision will allow the case to continue for the plaintiffs. But President Trump's lawyers may want it to be heard by the full Second Circuit, or eventually the Supreme Court. A link to that decision by the Second Circuit is in the show notes for this episode. In District of Columbia versus Trump, the District of Columbia and the state of Maryland sued President Trump, alleging violations of the Foreign and Domestic Emoluments Clauses similar to those in the Citizens for Responsibility and Ethics in Washington lawsuit. President Trump moved to dismiss based on standing and a failure to state a claim. On March 28, 2018, the district court ruled that the plaintiffs had standing, limited to injuries in the District of Columbia, based on alleged injuries related to the Trump International Hotel. On July 25, 2018, the court denied President Trump's motion to dismiss, holding that plaintiffs had stated a claim because the president was subject to the Foreign Emoluments Clause and the term emolument reached any profit, gain, or advantage of more than de minimis value received by the president directly or indirectly from foreign, federal, or domestic governments. These rulings were appealed to the Fourth Circuit, which issued a decision on July 10, 2019, reversing the district court on the standing issue. The Fourth Circuit panel concluded that the plaintiffs lacked standing to pursue their claims and remanded the case with instructions to dismiss. However, the plaintiffs may still seek petition for rehearing by the full Fourth Circuit Court or seek review from the Supreme Court. Finally, in Blumenthal et al. Versus Trump, 201 members of Congress have alleged violations of the Foreign Emoluments Clause through the president's receipt of foreign government payments at Trump properties, foreign licensing fees, and regulatory benefits, among other things. President Trump moved to dismiss on the grounds that the plaintiffs lack standing and that he has not received any prohibited emoluments. On September 28, 2018, the district court ruled that the plaintiffs have standing, reasoning that these members of Congress suffered an injury in fact through the deprivation of a voting opportunity under the Foreign Emoluments Clause. On April 30, 2019, the district court held that the plaintiffs had stated a claim against the president, adopting a broad definition of the term emolument as reaching any gain, profit, or advantage. After the district court denied the president's request for an immediate appeal, the president petitioned the D.C. Circuit, requesting that it stay the district court proceedings and review its rulings. On July 19, 2019, the D.C. Circuit denied the petition, but suggested that the district court had abused its discretion by not permitting an immediate appeal. On August 21, 2019, the district court certified an immediate appeal and stayed the case pending appeal to the D.C. Circuit. Thank you for listening to this episode. This podcast was created from a report titled The Emoluments Clauses of the U.S. Constitution, written by the Congressional Research Service. The Congressional Research Service is a group of nonpartisan shared staff to congressional committees and members of Congress, and they operate only under the direction of Congress. As I look more into the reports they create, based on some of the ones I've had a chance to look at, I'm likely going to be using them as a source for some upcoming episodes. As I'm thinking about creating future episodes, I'm planning on creating some longer shows. I've been trying to think of a good way to help thank the people that support this effort while continuing to make everything I create available at no cost. Because, much like with the Mueller report, I'll be reading those documents piece by piece. My plan then is to make those segments available to people supporting this podcast at insiderfriends.com or via glow.fm/insider. Once all the sections are complete, the pieces will be assembled into a full episode, and they'll be available to everyone who is subscribed to Government Unfiltered. Thanks again for listening to this episode, and I'll be looking forward to producing more episodes coming soon.